this online seminar organized by the Transnational Economic Law and Dispute Settlement Group in the framework of the Center for Comparative and Transnational Law at the Faculty of Law of the Chinese University of Hong Kong. Today we have the pleasure of welcoming Mr. Antony Crockett. He's the senior consultant at Herbert Freehills here in Hong Kong, where he leads the law firm's business and human rights practice in the Asia Pacific region. Mr. Crockett is a very experienced practitioner, and he combines expertise in these two fields of law that so frequently interact: business and human rights and international economic law. As probably many of you know, international economic law is one of the most important fields of international law nowadays, but it is also one of the most controversial. And one of the reasons for the mounting amount of criticism of international economic law over the last years has exactly to do with its potential detrimental impact on the human rights of the populations of host states, of the states where foreign investors make their investments. So to talk about this today, as I mentioned, we have the pleasure of welcoming a well-known practitioner and expert in these fields. As you can see from the pamphlet, Mr. Antony Crockett has experience in this field of business and human rights. He is a solicitor advocate of the High Court of the Hong Kong Administrative Special Region. He's also admitted as solicitor in England and Wales, and as a barrister and solicitor of the Supreme Court of Victoria in his native Australia. Antony, thank you so much for joining us today. The floor is yours.
Thank you very much, Fernando. Thanks for inviting me, and good afternoon, everybody. I have some slides, so I'm going to share my screen. Sorry, bear with me. I hope you can all see those slides now. As Fernando said, I'm going to talk about business and human rights and its relevance to international economic law, with a particular focus on investment treaty arbitration, mainly because that's one of my areas of practice, and so something I feel comfortable to discuss, but also because I think there's been some very interesting recent developments, both in relation to what states have been doing in their investment treaties in response to some of the criticisms of investment treaty law, in terms of that issue Fernando described about whether there is excessive weight given to the property and economic rights and interests of investors compared with the rights and interests of communities and local populations. There's also been some very interesting awards by investment treaty tribunals starting to grapple with some of those questions and issues, and they are interesting as well in terms of we see how these issues may arise in cases and how they may be dealt with in the context of a particular case. And so broadly, there are three parts to my talk this afternoon. I'm going to try and give you a very quick history lesson on the field of business and human rights. What are we talking about, both from an international law perspective, a domestic law perspective, but also practically what is business and human rights. Then briefly, discussion of these concerns in the field of investment treaty arbitration, and in particular, and this is really something in common to other areas of international economic law, particularly international trade law, concerns about whether international economic law sufficiently protects the right to regulate the so-called right to regulate of states, both in relation to human rights issues, but also issues of environmental protection, issues of public health, other matters of the public interest. More specifically to investment treaty arbitration, there are also concerns about the conduct of investors, and in particular the conduct of multinational corporations. That really is what leads to the whole international policy debate about business and human rights. It's been a debate very much focused on multinational corporate activity, although the principles that we will discuss will be equally relevant to at least from the business and human rights principles, and laws that are developing will be equally relevant to a purely domestic enterprise. And then I'll talk about briefly about some of the recent interesting case law. So, a history lesson on one slide. International human rights law really is a story of the last 50 to 60 years. In the wake of the Second World War, the United Nations adopted the Universal Declaration of Human Rights. While that document has some legal significance, it's not a treaty in the conventional sense, and so it's then not until the 1960s that you start to see conventional treaty law being developed on human rights. And 1966 was a very important year because it was the year that the International Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights were adopted, and which really sought to codify the obligations, and this is important, the obligations of states in relation to the protection of promotion and protection of human rights. And of being international treaties, of course, they impose those obligations on states. And international human rights law is an interesting field, and in some ways has similarities to the field of international economic law, more particularly investment treaty law, because it is an area where we see international law seeking to protect the rights of private persons, so individuals in the case of human rights, also legal persons, corporations, in particular in the context of investment treaties. And of course, it's also an area, human rights, international human rights law and investment treaty law, where we see those private actors seeking to enforce the obligations of the state. In the investment treaty context, obviously, through bringing investment treaty claims typically in international arbitration. In the human rights context, through referring human rights complaints through various mechanisms. You see, for example, the European Court of Human Rights, the Inter-American Court of Human Rights, but also other mechanisms and procedures that have been established pursuant to individual human rights treaties or by the UN to deal with or to adjudicate on questions of state compliance with their human rights obligations. When those treaties were adopted, while the rights in those treaties, you can pick any one of them and you can readily conceive of ways that private sector activity may impact upon those rights, the treaties are addressed really to the obligations of the state. Nevertheless, you then see in the 1970s considerable concern and activity then at the UN focused on questions of the activities of transnational corporations and the potential adverse impact of transnational corporate activity on human rights, but also at this time on the environment. And there was a series of initiatives at a UN level, but also at the OECD and also within the ILO, in terms of policy efforts to try and articulate some principles about how corporations should conduct themselves when operating across national borders, and really seeking to address the problem that you may have, and typically the concern was a Western multinational operating in a developing country in Asia or in the global South, and a perception that those Western transnational or multinational corporations were not complying with the same standards in those host countries as they would be obliged to comply with in their home countries. And that was in relation to a whole range of issues: labour standards, environmental standards, human rights standards. So you see these various initiatives through the 1970s and into the 1990s, the UN and these other organisations trying to reach some sort of consensus as to how to address that problem. And I think I haven't put it on the slide, it would be far too complicated, but you think that, also during that period, you have significant efforts of the international community to liberalise trade and investment. So the two things in tension with one another, states wanting to promote cross-border trade and cross-border investment, and because that was perceived to have make a positive contribution to development, including the achievement of various and promotion of various human rights, particularly economic rights, but at the same time concern about whether that transnational cross-border economic activity was being appropriately regulated. So really almost 3 decades of various attempts to address that problem, none of which resulted in any form of hard law. So no new treaties, a limited amount of development in terms of domestic law initiatives, really just a sort of a ongoing series of policy debates about what to do, and a tension between efforts at the UN, which were at that time very focused on the idea of trying to come up with a conceptual way to impose obligations on transnational corporations directly under international law, versus the other initiatives which were focused on seeking to encourage and facilitate responsible conduct by private sector enterprises, and the most prominent of that being the OECD guidelines for multinational enterprises, which were a series of recommendations addressed to multinational enterprises, addressed to the private sector, about how they should conduct themselves responsibly in relation to a range of matters, so including, for example, environment, corruption, now human rights issues, and they have some influence in the sense that OECD governments were making those recommendations, but they were of no direct legal implication for multinational enterprises, or indeed for any other private actor. These efforts at the UN continued through to the early part of the last decade, where a commission established under a mandate from the then Commission on Human Rights came up with a document called the UN Norms on the Responsibilities of Transnational Corporations and Other Business Enterprises with Regard to Human Rights. And this was an attempt to translate the obligations of states under the main international treaties dealing with human rights, and to translate or transpose those obligations into obligations which would have direct effect in relation to transnational corporations and other business enterprises. That initiative was very much opposed by a range of governments, in particular in the West, and ultimately the document and the proposals were not endorsed in what was then the Commission on Human Rights. in parallel to that process, there had continued to be the development of what I'm calling soft law, in terms of standards that are being developed by international organizations addressing these issues of responsible business conduct, but which were never intended and do not have any direct legal implication. And I think a very significant moment was in the year 2000 when Kofi Annan launched the UN Global Compact, which is now the world's largest corporate social responsibility initiative, and where companies, voluntarily decide to follow what the UN Global Compact says in relation to standards of responsible business conduct. And again, not confined to human rights, also issues relating to the environment, labour, and corruption. Notwithstanding that the UN Global Compact was and is a great success in terms of many corporations, joining that initiative, there was continued concern expressed by countries and NGOs and other actors that the problem had not really been properly addressed. The problem of particularly multinational enterprises operating across borders, not complying with international standards throughout the entirety of their operations. And so, recognising that there was this unresolved policy debate, Kofi Annan appointed a special representative. This was when Kofi Annan was the Secretary General at the UN. He appointed a special representative on the issue of business and human rights. And that was a professor from Harvard called John Ruggie, who happened to have been working at the UN, and he was one of the main architects of the UN Global Compact. But he was given a mandate then by Kofi Annan in 2005, following the Commission on Human Rights rejecting the UN norms. And John Ruggie was asked to try and come up with a new policy framework and a set of recommendations that the UN would adopt about how to address these ongoing debates and concerns about the potential for multinational enterprises in particular to have adverse impacts on human rights through failing to adhere to international standards. And so John Ruggie, over a period of 6 years, developed what is now known as the UN Guiding Principles on Business and Human Rights. And that's that set of principles that he created were unanimously endorsed in the Human Rights Council in 2011 and have now really become, a widely accepted international standard. They are referred to increasingly in the corporate human rights policies of most of the world's largest multinationals. They are referred to now in the OECD guidelines. They are referred to in a whole range of other standards on responsible business conduct that have been developed for particular sectors, such as the IFC performance standards of the International Finance Corporation, the Equator Principles, which are a set of environmental and social standards applied by more than 100 international banks in relation to project financing activities. Really a sort of near universal adoption of the UN Guiding Principles as a standard for of best practice in relation to ensuring adherence to international human rights standards in the context of private sector economic activity. Now, we'll come on to talk about really what the UN Guiding Principles say, but the other thing I wanted to emphasise in terms of this, what we've seen over the last, particularly 20 years, is development from soft law to hard law. And so the UN Guiding Principles are still soft law. However, governments in the UN Guiding Principles, the obligations of states to legislate to protect human rights are emphasised, and governments have paid heed to that, and they have begun progressively to introduce legislation that deals with and seeks to implement aspects of what is recommended in the UN Guiding Principles. And so since the Guiding Principles were endorsed in the Human Rights Council, we've seen, for example, modern slavery legislation introduced in the UK and Australia. We've seen non-financial reporting obligations in the EU and in other jurisdictions extended to cover human rights matters, and a range of other regulations and legislative instruments being introduced or debated, and which seek to implement some of the recommendations set out in the UN Guiding Principles. From an international relations perspective, it's very interesting because it shows how a soft law instrument may nevertheless influence how governments go about exercising their legislative and regulatory powers. You don't necessarily need a treaty in order for governments to decide to adopt legislation and regulation to achieve that what is recommended in that document. And for those of you who are studying international relations, this is something that John Ruggie has been in his academic career, that he has written a lot about in terms of the potential for soft law instruments and consensus on issues of policy at an international level, falling short of a treaty, but where you can nevertheless make significant progress in terms of seeing states adopt those recommendations and through regulation and legislation domestically. In terms of where this story and this history lesson ends, in 2017, France decided to make what's known as human rights due diligence, and I'll come on to briefly describe what that is, but that was made mandatory in France for large companies. That's led to a debate in the European Union as to whether mandatory human rights due diligence should be introduced on an EU-wide basis, and there is an active legislative initiative in the EU where there is an objective of imposing some form of human rights due diligence obligation for EU companies or companies operating in the EU. There is also an ongoing process at the UN level with negotiations for a business and human rights treaty. And so even though the UN Guiding Principles sort of represent a consensus on matters of international policy, but also the present state of international human rights law, you can't exclude the possibility that we might see some new international law in future in the form of a new treaty on business and human rights. I mentioned I'd briefly describe the content of the UN Guiding Principles. They're broadly divided into three pillars. The first is an emphasis on the fact that states have a legal duty to protect human rights, and that legal duty arises as a result of the obligations states have assumed by signing and ratifying international conventions on human rights. The second pillar explains that the private sector, business enterprises, have a responsibility to respect human rights. That's not a legal obligation. It's described in the UN Guiding Principles as society's expectations. Society expects that business enterprises will conduct themselves in a way that respects human rights. What does that mean? It means essentially that they should avoid, in their business operations and relationships, causing or contributing to adverse human rights impacts. So it's another way to think about it is it's a duty to do no harm. It's not a positive duty in the way that a state has a duty, an active duty to protect human rights, but it's a duty to not do anything that might have an adverse impact. And then the third pillar of the UN Guiding Principles deals with the importance of ensuring that victims of business and related human rights abuses have access to remedy. The UN Guiding Principles refer to, in terms of that, businesses' responsibility to respect human rights. It applies to all internationally recognised human rights. And so the rights on this slide are all internationally recognised. This is not a completely exhaustive list, but you can see through that list, lots of human rights which can potentially be impacted by the operations of businesses. So the right to privacy, we see ongoing debates about privacy in the context of online platforms and tech companies in terms of the data they collect and the issues that creates for individuals' right to privacy. Rights to property, where obvious that individuals' property rights may be affected by the activities of the private sector. Economic and rights like the right to work, the right to health, the right to education, etc. They're all rights that may be affected in some way by activities of the private sector. So as I said, the guiding principles don't impose any legal obligations directly on businesses, and they're non-binding, but nevertheless there is quite a lot of detailed guidance in the guiding principles about the steps companies should take to ensure that they meet that responsibility to respect human rights. And in particular, it talks about embedding respect for human rights into policies and procedures. And you can go now onto the website of most major multinational corporations and you can see that they have a corporate human rights policy, which will typically express a commitment to respect human rights, and then it will explain the steps that business takes to ensure that its operations are not causing adverse human rights impacts. The UN Guiding Principles also recommend that companies should undertake human rights due diligence. That means to assess the risk that their operations and activities may have an adverse impact, and then to take steps to avoid those impacts or to mitigate those impacts where they are identified. It encourages companies to report and to be transparent about the steps they have taken and the human rights risks that they have identified and they have taken action in relation to. And then I think importantly, it explains that having a corporate social responsibility program or engaging in traditional forms of corporate philanthropy, things like building schools or contributing money to community projects, etc. Of course, that activity is worthwhile and is encouraged, but you don't earn. It's not like carbon emissions where you can buy carbon credits. You don't earn offsets for your adverse impacts through engaging in corporate philanthropy in other areas. Increasingly, this human rights due diligence we see becoming a legal obligation. Human rights performance requirements are increasingly being incorporated into commercial contracts. Some of the human rights reporting obligations that have been introduced for corporations effectively impose a de facto due diligence obligation. So to give the example of the United Kingdom's Modern Slavery Act, that requires UK companies or companies with a business presence in the UK to report on risks of modern slavery in their operations and supply chains. What that means, in order to be able to say something sensible and meaningful in your public modern slavery statement, is that the business has to engage in some form of due diligence to assess what the risks of modern slavery in its operations and supply chains might be. And the official government guidance on reporting under the Modern Slavery Act emphasises that undertaking human rights due diligence is a way to responsibly address those risks and then to report on those risks. Then we see the introduction of mandatory human rights due diligence obligations. I gave the example of France, and then mentioned that this is something that the EU is actively considering introducing this year, where not only would there be a reporting obligation, but there would be an obligation to actively undertake human rights and in fact, environmental due diligence. The other thing that is driving this practice of undertaking human rights due diligence is the fact that companies have themselves adopted policies that include a commitment to undertake human rights due diligence is becoming relevant to questions about whether those companies therefore owe a duty of care in relation to potential adverse human rights impacts. So if you say in your corporate human rights policy that you have taken a range of steps and implemented a range of procedures to ensure that your operations are not causing adverse human rights impacts, that may provide evidence of the existence of a duty of care to persons who may be the victims of those adverse impacts. It may also be relevant to the scope of the duty of care that a company owes. And you can, those of you who will have studied tort law will know how in the common law the question of the scope of a duty of care is considered. You look at the standard of a reasonable person, but then you can readily appreciate that if a corporation has said in its own human rights policy that it takes certain steps to ensure that it is not causing or contributing to adverse human rights impacts, you can see how it may be then difficult to defend against an allegation of negligence where the company has failed to comply with its own policies and procedures. And so this is something that we increasingly see in litigation against corporations where there are allegations of negligence and which are based on a company's failure to adhere to its own policies and procedures in relation to human rights, but also environmental and other matters. Now, how does this all become relevant to investment treaty arbitration? Those of you, I know many of you have been studying investment treaty arbitration as part of your LLMs, and so you will be familiar with some of the debates that have arisen about investment treaty arbitration, and famously what was described as the backlash against investment treaty arbitration, where all of a sudden in the late 1990s and into the 2000s, there was a huge explosion in the number of investment treaty claims. And in fact, investment treaties had been being signed by governments since the 1960s, but there had been, until the 1990s, very few claims made. And then all of a sudden, there were a large number of claims in North America under the NAFTA. There was a huge number of claims against Argentina following its financial crisis. And every year now, we see more and more investment treaty claims. Apart from the fact that those claims and those disputes often involved very significant sums of money, which in itself was enough to generate public concern in terms of the potential impact of those cases for budgets of governments. The cases also started to touch on areas of regulation, which very much implicated issues in the public interest. So investors bringing claims in relation to environmental regulations, in relation to public health regulation, and seeking to challenge regulations that had been introduced and which had affected their business, and on the grounds that those regulatory measures were not consistent with the protections that were guaranteed under the investment treaty in question. That backlash came slightly later, but was more or less consistent with some of the anti-WTO arguments that were going on in the globalization debates that led to the famous protests in Seattle and other places, where there was this same criticism that international trade law prioritized the liberalization of international trade ahead of other important matters of public interest, such as environmental protection, public health care, the maintenance of high standards in relation to food safety, for example. It was a very similar debate in terms of this criticism that these bodies of law, investment treaty law and international trade law, didn't pay sufficient attention to the importance of protecting human rights, the importance of protecting the environment. In the investment treaty context, this debate led to this discussion of whether investment treaties might have what is called a chilling effect. And the theory is that the threat of a potential claim from an investor in relation to some piece of environmental or social legislation, the mere threat of an investment treaty claim would be sufficient to deter a government from introducing that regulation or taking that regulatory measure. And that translates into an argument that investment treaties threaten the so-called right to regulate of states. And there's been an awful lot of academic research and commentary. I think it's fair to say there is very little evidence that investment treaties in fact have that chilling effect. Nevertheless, it has been something that has been a significant concern of governments, and so we start to see states modifying the provisions that they are including in investment treaties to try and protect the right to regulate, and in particular in relation to the topics that had become controversial, such as public health, environmental protection, human rights issues. The other controversy, and this has become a little bit more topical in some of the recent cases, was states also and other critics of the system also saying that it is one-sided. So the inquiry is only into whether regulatory measures or other measures taken by the state are consistent with the investment treaty, and no attention paid to whether the investor had conducted themselves responsibly, whether they had engaged in bribery, whether they had a good record of complying with environmental regulations, whether they had a good record of complying with other regulation in the host state. And that's something that has also become a focus, both of how states defend investment treaty claims, but also the types of provisions that are being included in more modern investment treaties. I've got on the slide a quote from a public statement that was made by a number of very prominent academics in the field of investment treaty law, which really just encapsulates those criticisms I've been discussing about investment treaties potentially impinging on this so-called right to regulate, the fact that rights of investors were perceived to be being given more weight or put ahead of the human rights and other issues of the public interest. Criticism of arbitrators for interpreting treaties in that way, interpreting treaties in order to protect private property and economic rights, but not paying sufficient regard to questions of protecting the environment, protecting human rights, etc. Before coming to the case law, I wanted to just engage in a little bit of, I suppose, let's call it myth busting or devil's advocacy. The threat that investment treaties are said to pose to the right to regulate is now something that everybody readily understands in terms of the theory. What I think is interesting is the language that gets used, that states talk about a right to regulate, and we even see that reflected in the language of treaties, as though it was ever in any doubt that states have a right to regulate within their territory in relation to all manner of matters. And it is in the nature of signing a treaty that governments are constraining their sovereignty in some way, or assuming some obligations to other states internationally that may constrain their ability to regulate within their territory. But I think that language of states have a right to regulate is interesting. It sort of tries to put states in the position of somehow being a victim of a powerful multinational corporation. At least in the area of human rights, states don't have a right to regulate, they have an obligation to regulate. And so the international covenants both have a common article in Article 2, which imposes on states an obligation, and this is an ongoing obligation, to adopt laws and other measures to give effect to the human rights that are recognised in those international treaties. And that has been interpreted by international courts and by the UN Human Rights Committee as including an obligation to legislate and regulate the private sector in order to ensure that private sector activities are not adversely impacting on human rights. So it is not a question of whether the state has a right to regulate. The state actively has an obligation to regulate to ensure the protection of human rights. I mentioned that states, though, have started to address these questions in terms of how they draft treaties, and you do see quite a significant evolution of the language being used in investment treaties. And so, whereas once upon a time the preamble to an investment treaty would talk about the objective of encouraging cross-border investment between the two countries or between a group of countries if it was a multilateral treaty, and as if that was something that was good in and of itself, you now see treaties increasingly referring to an express objective of promoting sustainable development. So not just promoting any sort of economic development, but promoting sustainable development. You also see, as I mentioned, provisions that refer expressly to the state's right to regulate. Some of those become quite detailed, and they carve out certain matters from the scope of the treaty so that investors are not able to bring claims in relation to certain regulatory topics. So, for example, a number of states who have faced investment treaty claims relating to tobacco regulation have now completely carved out tobacco regulation from the scope of their investment treaties. Alternatively, the approach may be to impose a more stringent test in relation to certain areas of regulation so that the investor faces a higher hurdle to prove that, for example, an environmental regulation constitutes a breach of the investment protection provisions in the treaty. The other approach that has been taken, and this has been more common in multilateral investment treaties, but is to include a general exceptions provision similar to Article 20 of the General Agreement on Tariffs and Trade, where the approach is to exempt a range of regulatory areas from the obligations under the treaty, subject to some provisos, and in particular the provisos that you see in Article 20 of the GATT, that the measure must not be, an environmental measure which is really just using the environmental label as a disguise for a measure which is discriminatory against a certain investor on the basis of nationality, or which is arbitrary. That's another approach that has been taken. I think interestingly that I'm not aware that any of those general exceptions provisions have been tested in a case yet, but they obviously raise the interesting question of whether, when you have that GATT style provision included in the investment treaty, the extent to which the investment treaty tribunal should then pay regard to the jurisprudence that's been developed in the WTO dispute settlement system about how those general exceptions provisions are to be interpreted. The other, I think, sort of innovations in treaty drafting that have been designed to address some of these concerns include references to corporate social responsibility. Usually those are hortatory and not mandatory, so it's just a statement by the governments that they intend to encourage corporate social responsibility and adherence to international standards, but without that imposing any obligation or being articulated in any sort of mandatory language. The other provisions that have been introduced, which are, I think, focused on this question of the conduct of the investor, are provisions that state expressly that investors must comply with applicable local laws. And you see that that is a provision that may, allow the state to defend a claim by saying that the investor is disentitled from bringing a claim because it's failed to adhere to local law. And that was a defence that states were already making, but the case law had become quite complicated in terms of whether tribunals were prepared to accept that some illegality in connection with the making of the investment or in connection with the operation of the investment, what illegal conduct would be sufficient for the tribunal to say that it was going to dismiss the claim entirely. That had been quite controversial and something that I think states are now trying to clarify through more detailed language in the treaties themselves. So coming to some case law, I'll go through this quite quickly because I've put the cases on the slides and you can read them at your leisure. There's this series of decisions around a decade ago where there'd been this criticism of investment treaty arbitration tribunals construing investment treaties in isolation of other provisions of international law. And famously, former Judge Bruno Simmer of the International Court of Justice was very critical of investment treaty arbitrators, saying that they were all people from a commercial background who saw investment treaty law as this sort of isolated specialist field of international law, and they didn't need to know anything about human rights law, and human rights law was not ever going to be relevant to the resolution of a case. We then start to see some awards around a decade ago where tribunals start to say, clearly investment treaties will need to be interpreted consistently with international human rights law. And I think, interestingly, how this manifests itself initially, the example from the Suez case against Argentina, and this was a dispute about concession to operate water supply infrastructure in Argentina. And Argentina defended the claim, among other things, by saying that the investor had failed to ensure adequate water supply to certain communities, and that was a violation of the right to water. And the tribunal emphasised, in fact, that Argentina has, as the state, has human rights obligations and has investment treaty obligations, and it must respect both of them. And so it's not a question of inconsistency or contradiction. It's for the host state to determine how to achieve the protection of human rights consistent with the obligations it has assumed under investment treaties. And so Argentina's human rights defence in that case failed, but the tribunal has obviously made clear that, you know, these two obligations can coexist alongside one another. Coming forward, another case again about water, and again involving Argentina, and this one more interesting because this time Argentina is making a counterclaim and saying positively that the investor has violated the right to water. Interestingly, in that case, the tribunal decided that that counterclaim had no merit, but it accepted in principle that the tribunal had jurisdiction in relation to that claim. And there's a passage of the award on the slide highlighted where that the tribunal appears to suggest that a multinational may even become, or a company may even become a subject of international law for this purpose. I think that, you know, we could argue all afternoon about that, but very interesting in terms of how it shows quite a shift in the way that tribunals were treating these arguments, that they were prepared to assume as a matter of principle that they could hear a counterclaim from the host state that the investor has failed to comply with international human rights standards. And then the last case I wanted to discuss before we, sorry, I'm just checking on my clock, before we have some time for discussion, is this is a case where part of the host state's defence was focused on the investor's conduct. And this Bear Creek versus Peru was a case about the cancellation of a mining license, and the mine was in development. It hadn't started to operate profitably, but it was substantially developed. The mining company had a terrible conflict with the local community. That community had been complaining about environmental pollution and all sorts of other complaints about how the company was operating the project. And it was partly because of the community opposition to the mine that the authorities in Peru decided to cancel the mining license. Now, the tribunal concluded that Peru had acted unlawfully in terminating the license in terms of the process that was followed. However, the majority of the treaty, so in other words, had the investor continued to have its mining license, it would have faced ongoing issues operating in Peru and costs because of the fact that it had done such a poor job of managing its environmental and social impacts. And then interestingly, Professor Philippe Sands was on that tribunal, and he gave a minority opinion where he also suggested that damages could be reduced based on a concept of contributory negligence or contributory fault by the investor, which was a slightly different approach. But also, interestingly, Professor Sands said, he referred to, and the community that was opposed to this particular mining project was an Indigenous community. And Professor Sands referred to the 1989 Treaty on Indigenous and Tribal People's Rights. And he makes the observation that while that convention doesn't impose obligations directly on private companies or private persons generally, of course it's something that a private company should have regard to in terms of determining how to conduct its operations, and in particular, how to conduct its relationship with that local Indigenous community. And so I think we'll continue to see host states start to raise these arguments about investor conduct more frequently, in particular because Bear Creek opens the door to this idea that it is a way to reduce the damages payable to the investor. And in fact, this is a fact pattern that can become quite common in investment treaty arbitration, where the state has taken some regulatory measure, such as cancelling a contract or cancelling a license, and it has gone about that in a way which is not consistent with the protections guaranteed in the treaty, things like due process, for example, but where equally it has had reasons for doing that, for example, because the investor has not been operating responsibly in the host country. And I think we'll see many more disputes where these issues really come into focus. And so I think Bear Creek is a very significant award, and I would commend it to you in terms of reading the analysis that the tribunal makes in that case. And that brings me to the end of what I wanted to talk about. I'm very happy to take questions. Fernando, I'm not sure if we're doing it via the chat function or people can unmute themselves and speak on Zoom.
Thank you so much, Anthony. Yes, I forgot to mention that in the beginning, but those who wish to submit their questions or make any comments can do so through the chat box function, or I believe they can also unmute themselves. So we still have plenty of time. We have around half an hour. So I open the floor for questions, not without thanking you first, Anthony, because you really offered a very interesting review of some of the most hot topics in this very controversial field, and this interaction between human rights and foreign investment. So I open the floor for questions. If there are no questions, maybe I'll kick off the discussion with a question myself to give other participants a few more minutes to write down their questions. I actually have a few questions. So maybe let's start with you mentioned at some point arbitrators, the individuals who are in charge of settling these disputes. I personally believe that a lot of the criticism surrounding ISDS in the end has to do with who are the members of these tribunals. And one of the criticisms that has been made, as you have mentioned, Anthony, is that they have a commercial law background, that they, some authors even believe they are pro-industry, that they are biased. And even if they aren't, they do not really have particular background and expertise in the field of international human rights law. And so it has been suggested, for instance, that they should. Potentially in the future, in the framework of a permanent bench, a permanent investment court. Do you think that this is still the case? If I remember correctly, in the beginning, some tribunals evaded the question based on issues of jurisdiction. They were not really sure that they were empowered to deal with these questions. Slowly, as you mentioned in the water cases, they started approaching the topic. Do you now think that there is a sufficient pool of people who have expertise in this interaction of different domains of public international law? And is it desirable to require that they do have that?
I think that's a good, this is still a very, I think, pertinent issue. One of the, I mentioned the criticism Bruno Simmer made, which I think was a fair criticism. Since he made that criticism, I think there's been some progress in terms of, particularly by institutions like ICSID, in terms of just trying to increase the pool of arbitrators, for one, which helps because there was a very small group of arbitrators sitting in the majority of the cases. And in fact, that was one of the groups that Bruno Simmer was criticising as people who perhaps weren't very interested or knowledgeable in other areas of public international law. And so there has been some progress. There are two problems, though, in terms of, I always say to students when they're critical of decisions made by arbitrators, they think that some question of environmental protection or human rights or what have you has been overlooked, and that the decision is not compatible with those objectives or with international standards. I always encourage them to go and, where they're available, to read how the state argued its case, because in fact what you will find in a lot of the cases is there was no point taken by the state in its defence that the measures that it had adopted had some objective of environmental protection or had some legitimate objective of promoting some, protecting some human right. And so it's important not to criticise arbitrators when the issue hasn't been brought before them. This was, of course, one of the reasons too why you started to see NGOs seeking to intervene in investment treaty cases as amicus, because they were saying no one is doing a good job. The states aren't raising these issues in their defence. The arbitrators aren't raising them of their own volition. And of course, there are problems in arbitration for arbitrators, bringing up issues of their own volition. It creates all sorts of, concerns about, potential challenges to the award if the tribunal of its own motion starts to consider points that are not raised by the parties. But I think you can be critical of states for not thinking about the defences, but also it's worth looking at the lawyers advising the states, because often the states go to the same lawyers as the investors, and you have these people who perhaps spend most of their time being commercial arbitrators, and the idea to bring up the human rights defence or, doesn't occur to them. But also, to be fair as well to those defence lawyers, those arguments may not have any basis in fact. So, you also need to look back and say, was this measure adopted by the state, genuinely adopted with the objective of, for example, protecting the environment, protecting human rights? And so there's a challenge for everyone involved in the system in thinking about how you make sure that where the issues are relevant, that they get ventilated. And I think that we do see a degree of progress with that. In terms then specifically also of the composition of tribunals, there's the tension between, on the one hand, ensuring that the decision makers are appropriately experienced and qualified and independent and don't have preconceived views, but equally the tension with the concept of it's like a totem in arbitration, the party autonomy to choose their own arbitrator. And actually, interestingly, I think that increasingly is more important to states than it is to investors, in the sense of most companies never bring an investment treaty claim. Corporations are not sort of invested in the system in the same way that states are. States are the repeat litigants. And it's something that I've observed in the commentaries about the EU-China agreement and the investment chapter to be negotiated for that agreement, where the EU is pushing its idea of the permanent investment court model, whereas China has emphasised this desire to have that the parties have some role in choosing the tribunal. And that's something that's, as I say, a sort of a totem, not just in commercial arbitration, but in interstate arbitration, and indeed in the composition of the ICJ, you know, governments wanting to have a say in who gets appointed to the ICJ. And it's quite reasonable, I think, that states have that concern, but it does create an issue about ensuring that the right people are, or that appropriately qualified decision makers get appointed, as opposed to people who may be appointed for political or you know, other reasons that don't relate to their qualifications and experience.
Thank you, Anthony. Going back a bit to the point you raised, which I totally agree with, when you mentioned that probably in the cases against Argentina didn't really make a very strong argument that it was acting to protect the human right of its population to water. If I remember correctly, because I did look into those cases a few years ago, maybe one of the reasons for that was that, ironically, that argument could backfire, because other provinces and other cities beyond Buenos Aires, and they could argue, oh, is that right? So we do have a human right to water, and so it could actually backfire, because Argentina in that case would probably see lawsuits in different provinces of the country demanding that the state provide water to the population. So my impression was that at the time they alluded to this a bit as an attempt to decrease their responsibility or their liability, if there was any, but they were not themselves very, at least it did not transpire from their arguments that they were truly convinced about that. So it was more of a question to try to deflect some of their liability.
I think that's right, and I think you see the development of the awards, the ones I mentioned too, that those arguments are raised in the Argentina cases as sort of, it was a quite half-hearted defence. It was not convincing. The tribunal makes the observation. It says Argentina has the obligation to protect the right to water. If Argentina wanted to ensure that the communities that they were concerned about had proper access to water, they could have written that into the concession contract. You know, the obligation is to ensure adequate service to these areas. You know, that they were not persuaded that had been Argentina's objective when the concessions were set up. If you look at some of the more recent cases like Bear Creek, the defence is more convincing, including because the state has some evidence of what its motivation was, and that the state itself was attempting to, you know, follow its own international obligations, and that will be critical with these cases, that the state actually has a genuine, that the defence is genuine in the sense of what was motivating the measures taken by the state was in fact the goal of complying with some other international obligation, which is, as I say, why as a student it's important to read the submissions that the parties make before you decide to be too critical of the reasoning of the tribunal, because the tribunal is dealing with what the parties has told them are the issues in dispute.
If I remember correctly, in one of the very first cases, the legal counsel for Argentina flew a few days before to Washington to buy a few books and prepare for the hearing. So actually, the legal department learned a lot from experience. It was a painful learning process, because Argentina at the time was fighting on several different fronts. And so I agree with you. We also need to look into questions of legal representation. Who is representing these states? And I also agree with you when you mentioned the question of whether are states truly interested in having a permanent bench of arbitrators? and doing away with the traditional appointment model, which the European seems to be an advocate of. I think that's more for internal consumption, honestly. It's more to address the public criticism of ISDS. So what I mean is that I'm not truly convinced that states really prefer to have a permanent bench of appointees of judges that, as you mentioned, and we know in international permanent courts are frequently submitted to a process of political scrutiny. Okay, again, we still have time. Please, anyone, and again, apologies for not mentioning this in the beginning. If you want to speak up, that is fine. I think you have the ability to unmute yourselves.
Can you hear me?
Yes, Dini, please.
Yes.
Yeah. Hi. Thank you for your talk. It was really interesting. Well, first of all, I have a comment on regulatory chill. When I was working on a project a few years ago on the impact of plain packaging regulation, I found out evidence that several African countries, they were working on similar regulation as the plain packaging in Australia, and they decided to stop the implementation of this regulation due to the concerns on the outcome of the Philip Morris case. So just a short comment. Then the question, you mentioned the CPTPP that has carved out the tobacco investors from the investors, from giving them ability to bring a claim in the case. Don't you think this is unfairly discriminatory to a specific type of investors? And we know that there are other companies that invest in more dangerous or less moral sectors, such as weapons or of any kind, or sectors that are even probably more detrimental to the people. So why to discriminate tobacco companies? We all know that tobacco is harmful. And the third point regards the labor rights. We know there is a great concern about the impact that working condition can have on specific working groups, and there are efforts from both the European Union with their own treaties and treaties drafted by US and Canada to include chapters or provisions that provide for the implementation and inclusion of the 8 core conventions of the ILO and their ratification by the states that are their counterparts in these new treaties. Do you think we will see some implication in investor-state arbitration with respect to labor rights, to the protection of labor rights?
They're both really good questions. In part, they both have the same answer, and I think those two provisions you identify, or types of provisions, because they're being used by various countries, but they're catering to a domestic political concern. So Australia started to put carve-outs in treaties about tobacco because of the uproar in Australia when Philip Morris brought the claim against Australia, which Australia, of course, won. And so you can question whether there's any need to have a carve-out when the claim proved to be unsuccessful. But it was something that's in there really as a political, I think, to ensure that the treaty could get through the Parliament without anyone saying we shouldn't be signing this because we'll face another $10 billion claim from a tobacco company. Equally with the labour provisions, that something that the US has been pushing and that the EU then more recently, my understanding of why they're in there is because the labour unions in the EU and the US respectively opposed to the idea of jobs going offshore, and see the issue of lower labour standards, for example, in countries in Asia, as a way to sort of lobby against investment treaties, because the investment treaty in fact facilitates that offshoring. You'll go and build a factory in the country in Asia where it's cheaper because of the lower labour cost and potentially the lower labour standards. You wouldn't do that if there wasn't an investment treaty. So the labour clauses are in there to ensure that politicians who may otherwise be sympathetic to those arguments of the labour unions in the US and EU don't stop the treaties getting passed. You then look at the enforcement of those provisions, and there's not much happening, although some of the unions are getting a bit more aggressive in the US about lobbying the government to actually enforce those provisions. I do think we will start to see this issue come up in disputes, because one of the very, very sort of in the field of business and human rights, the modern slavery issue that is now receiving so much attention all over the world, you see an increasing amount of regulation. You also see increasing economic impacts of it, in the sense so a number of Malaysian companies producing anything from palm oil to rubber gloves were barred from importing their products to the US. So there's an immediately significant economic impact of being associated with a modern slavery allegation. And you can see how then there will be increasing pressure on the host countries to start improving their regulations. And whenever you have regulatory change, you have the risk of investment treaty claims. And I think we'll probably start to see some issues around the way that labour regulations might get changed in a way that is very detrimental to a particular sector, and that then prompts some claim that it's unfair. And one of the areas where you can potentially see it happening is the gig economy, where there are various, businesses, the gig economy, their platforms, which the economic viability of their model depends on a particular labour arrangement, and they could potentially be regulated out of existence. And it's that sort of existential regulatory change that can provoke an investment treaty claim. And so, I think in the next 10 years, we'll almost certainly see a claim that directly implicates a question of, labour law reform. I think rather than the supply chains, it's more likely to be that type of gig economy issue, but who knows? I mean, I'm just gazing into my crystal ball ignorantly.
Antony, if I may, another question. In your crystal ball, do you foresee the possibility? There has been a lot of discussion about potential investment treaty claims based on measures adopted by host states to deal with the coronavirus situation. Do you anticipate the possibility of host states invoking the human right to health as a justification for such measures? For instance, lockdowns, travel restrictions?
I think it's an area where a claim is relatively likely, especially because of the fact that some of the restrictions in various places also have a very nationalist tinge. And in fact, it's something that host states learn later to their dismay, that having politicians going around making nationalist commentary and is very dangerous in an investment treaty context, even if the measure has some legitimate, public health goal. Once you have politicians start, talking about things in terms of nationalism and, making disparaging remarks about other countries that may be the targets of the measures, that becomes very problematic for the defence of an investment treaty claim. And so I think because of the fact that some of it, if there is a case, there'll be the question of whether the measure is proportional to the public health issue will most likely be what the case turns on. However, I think we will also see these issues of the fact that the measures in many places have become tinged with these sort of nationalist goals, and the nationalist goals are don't necessarily relate to pandemic control. So there's questions about countries seeking to protect certain industries which are nationally important ahead of others. Because if you think about the impact, but also the response to the coronavirus, not just the public health measures, but the subsidies that have been rolled out, and whether those have been targeted on a defensible basis in terms of potentially discriminating against certain sectors or certain industries, and where again, if you have issues of the nationality of investors in a sector start to become part of the political commentary or the political decision-making process, that becomes very dangerous.
That's very interesting. I agree with you that it is very likely that sooner or later some of these measures adopted by states may result in investment treaty claims. I also agree with you that some of them are more for internal consumption than anything else. I would actually invite you and others who are joining us today, and I apologize for the shameless self-promotion, but I will be talking about travel restrictions and international law on the 7th of April, not from the perspective of investment treaty arbitration, but from the perspective of human rights treaties and the international health regulations. And as you mentioned, I looked a lot. The lawfulness of some of these measures has to do with something that you mentioned. Necessity, scientific necessity of these measures from a public health viewpoint, that I'm really not sure all of them would meet that requirement, but also very importantly, proportionality, as you mentioned. And I have serious doubts, for instance, that a travel ban meets this requirement when, for instance, the human right to return to your home country is denied, as happened in some countries. In addition, the third requirement, which is important, is that measures should not be discriminatory. And some of them clearly seem to assume that some people are a health risk when others are not. Truly a fascinating topic. I don't know if you would like to make some additional. I know everyone's tired of hearing about COVID-19, but we still have 5 minutes if you would like to make any additional comments on the impact of COVID in the field of human rights law and in the framework of investment treaties. That would be great.
Yeah, I guess just two very, very quick concluding remarks. I think the very interesting thing about what happened with the pandemic is all of a sudden people were very interested in human rights law. And so you saw that all around the world, people saying that their human rights were being violated. And I think it's great that people are having a dialogue in terms of thinking about how governments are exercising their regulatory powers and whether that's consistent with human rights law. And actually, this is another area that you can have a very interesting discussion on, is the degree to which there is actually, a lot of overlap, and the field of investment treaty law, many of the sort of key standards of protection are very similar to the types of standards we see applied in a human rights context. So questions of necessity and proportionality, but also the discrimination point. A significant proportion of investment treaty cases involve issues of discrimination. on typically on the grounds of nationality, and that I think is there's a lot that the two fields or regimes can sort of learn from one another, and indeed you see, particularly it's been the case that in investment treaty cases, arguments are being made based on principles of international human rights law, so that the one can inform the other. And the COVID cases, when and if they happen, are definitely going to bring that, very, very firmly into focus, because states will point to the fact that they have obligations to protect public health, and so that the positive obligation of the state to protect public health is going to come right into focus. And
thank you so much, Antony. Fascinating topics, and a lot of food for thought, that's for sure. Allow me just to take 1 minute to share with the audience our forthcoming events. On the 23rd of March, we will have a seminar titled Towering Judges, Comparative Study of Constitutional Judges. That's 23rd of March from 5 p.m. with my good colleague Rian and Ido Porat from the College of Law of Business, and several other panelists both from CUHK Law and other institutions. On the 25th of March, we continue our cross-border legal issues dialogue seminar series with a discussion about the latest developments of the Hague Convention on Private International Law and the Hague Judgments Convention by Professor Yun Zhao from Hong Kong University. And finally, we will also have a discussion about COVID-19, because it's the topic of the hour, from the perspective of children's rights by Professor Anne Scully Johnson, who is an adjunct associate professor here at CUHK Law. Antony, once again, thank you so much for your time. Thank you so much for your questions, and also to Dini for sharing his comments and raising thought-provoking questions. I wish you all the best of health. That's the most important thing right now. And I will see you soon here at CUHK Law.
Thanks, Fernando. Bye-bye, everyone.
Thank you. Bye.